It's time to talk about the scariest topic in law school, mergers. This will be one of the most important videos you will ever watch on this subject. Before we dive in, I'll be dividing this video into chapters on YouTube for easy referencing. If you are confident and you want to go straight to the procedures without any backstory, then go to this timestamp right here. If you want to fully understand mergers so that you can confidently smile on your way to the exam hall, then watch the video in its entirety. You won't regret it. Let's go. Honestly, I don't know where to start, but if we have to start somewhere, let's start with the definition. What is a merger? A merger is basically two companies coming together to form a mega company. So with their combined resources, they either form a new entity or one gets subsumed into the other. Usually, the acquiring company is acquiring at least 51% of the target company's shares. Side note, an acquiring company is the company trying to acquire shares. The target company is the company whose shares are being targeted for acquisition. An example of a merger is that of Access Bank and Diamond Bank that happened in April 2019. Both banks merged together and became a stronger Access Bank. Another example is the merger between UBA and Standard Trust Bank in July 2005. The two banks merged and became a stronger UBA. Now, before we dive into the procedures proper, I want to give you a little history lesson on the laws guiding mergers and acquisitions in Nigeria. Don't worry, we're not going to go too far back to the Bubble Act. We're only going back by 3 decades. So in the past, mergers were kind of guided by Karma 1990. It usually involved a scheme of arrangement, that is, an arrangement between the two companies that want to merge. And then the court would sanction the scheme, that is, the court would approve the agreement and boom, merger. If that sounds familiar, it's because the law was maintained and can still be found in Karma 2020, section 711 to be exact. The takeaway from this is that there were mostly procedural rules guiding mergers, but nothing specific on competition or thresholds, meaning that two entities could merge and monopolize the sector, and nobody gave a damn about it. And then 2007 came, and we got the Investment and Securities Act 2007 that replaced the 1999 Investment and Securities Act. It was this legislation that governed mergers in the country and gave a threshold for companies based on their annual turnovers. So we had this for a while until the SEC Rules 2013 came into force, adding to the ISA. It provided detailed procedures for mergers, takeovers, and acquisitions in Nigeria. If you're using the old textbook, this is the procedure you'll find there. Now, this is what we used for a long time until the Federal Competition and Consumer Protection Act was enacted in 2018, which became effective in 2019. Now, among other things, this act was meant to guide merger procedures, as that had to do with federal competition. See, right here, mergers. Now, the problem with this was that the 2013 SEC rules didn't align properly with the new FCCP Act, which caused a lot of confusion in textbooks and handouts. So to fix that, the SEC Rules 2021 came into play, and in those rules, SEC clarified its stance about merger regulations, saying, "We are no longer in charge. We haven't been in charge since the FCCPA came into force. FCCPC is the captain now." SEC still maintains oversight for mergers involving public companies to ensure transparency and investor protection in the capital markets. In other words, if it involves public companies, SEC has to check your merger. Now currently, the ISA has gotten an update in 2025, repealing the 2007 Act and modernizing capital market regulation overall. And when it comes to mergers, the SEC Rules 2021 is still what's applying for SEC's limited rule. The reason for this is because the FCCPC has taken over competition review. So the new ISA and SEC rules and regulations focus on debt security, investment protection, etc. So the main takeaway from this is, when it comes to mergers, FCCPC is the main regulatory authority. But then if the companies that want to merge involves a public company, then SEC also has to check that merger for the interest of the public investors. Now that you have this little history, let's look at FCCPC's role in mergers. Now, what's up with mergers and federal competition? Mergers can be very good as it helps companies increase output of products. Companies can also be more efficient when they have a combined capital. There are actually good upsides to mergers, but there is a downside. Monopoly. This means that the company becomes so powerful that it puts all of its competitors out of business. When that happens, the last company standing becomes the only one in that particular sector. and as a result runs the risk of being complacent, which would result to lower quality products, higher cost of goods, which is a positive for the company and a negative for us consumers. You see, we need companies to compete against each other in business. Then it forces the big company to step up by improving its services as well. And we as consumers get better quality products at a more affordable price range. Now, when FCCPC is notified of the merger, it will then investigate and run different checks, which can include asking fellow competitors, visiting sites, interviewing witnesses, basically different sources of information gathering. If FCCPC sees that the merger won't substantially lessen or prevent competition, then it will allow the merger to happen. If it will lessen or prevent competition, then FCCPC will consider if the merger will result in technological efficiency or pro-competitive gain to offset the negative downsides of competition we talked about earlier. If the gains are more than the downsides, the merger can still happen. FCCPC will also consider if the merger will be in the interest of the public at large. If it is, then the merger may be allowed. Now that I'm done with the background, it's time to talk about the procedure itself. Remember, it's a procedure for notifying FCCPC of your merger. It can be divided into 3 stages: the pre-notification stage, the notification stage, and the post-merger stage. Let's begin with the pre-notification stage. Now, when two parties want to merge, they usually draft an agreement between themselves called a Memorandum of Understanding. This is for when you are still in the negotiation process. Nothing is transferred yet, and there's no merger yet. It's just an agreement letting you know you're on the same page with the company you want to merge with. Afterwards, the acquiring company will run an investigation on the target company so that it knows the type of company it wants to merge with. This will allow the acquiring company understand the target company's assets and liabilities. This is what is known as conducting due diligence. It involves many professionals like solicitors, accountants, estate valuers, etc. After the due diligence has been conducted, the parties are strongly encouraged to request for pre-notification consultations with FCCPC at least 2 weeks before submitting their main notification form. This helps the merging parties clarify certain issues like whether or not the merger even needs to be notified in the first place, or calculating the annual turnovers to know if it will be a small or large merger, or whether they will use a simplified process or the normal process, etc. These consultations will help give the merging parties more knowledge before they start the actual merger notification process. Now let's talk about small and large mergers. In the SEC rules, it stated the threshold for small mergers, intermediate mergers, and large mergers, which you can see on the screen right here. But remember, SEC is no longer the regulatory authority. That's FCCPC now. So we will check the FCCP Act to see what it says about a small and large merger. Okay, section 92 defines a merger. Subsection 4 further defines a small merger and a large merger. And it's as vague as ever. It just says value at or below the threshold for small mergers and value above the threshold for large mergers, all stipulated by FCCPC. Luckily for us, we have this, a gazette containing the notice of the threshold. In this, we can know what a small and large merger is. It basically says that at the end of the financial year, before the merger is implemented, a large merger will be one where either both the combined annual turnovers of the acquiring company and target company exceeds 1 billion naira, or the annual turnover of the target company is equal to or exceeds 500 million naira. What this means is that inversely, if the combined turnover of both companies is less than 1 billion naira, it's a small merger. Also, if the annual turnover of the target company is less than 500 million naira, it's a small merger. Now that we're done with pre-notification and we have an idea of what a small and large merger is, let's go straight to the main notification process. Now it's time for the actual notification process. Buckle up guys, we're in for a ride. So now that we've known what a small and large merger is, that can come into play as to whether or not they are required to notify FCCPC of the merger. Now if the companies that want to merge, who I will be calling merger parties from time to time, find out that what they have is a small merger, then the parties don't need to notify FCCPC about it. But they can do it voluntarily if they feel it will substantially prevent or lessen competition. If it's a large merger, however, then FCCPC must be notified. During the time they are notifying FCCPC, the parties must not take any steps to implement the merger, whether before or after the notification, until FCCPC approves the merger. If they take any steps before the approval, they would be void. Now, based on Section 94 of the FCCP Act, there are usually two levels of review that FCCPC will do. The first detailed review, which is like the first quick look, and the second detailed review, which is an in-depth investigation. We'll also refer to them as Phase 1 and Phase 2. So if FCCPC does the first review and is convinced that the merger will not substantially prevent or lessen competition, then it will approve the merger. If FCCPC is not convinced, however, then it will do a second review, which will be a lot more in-depth than the first one. Now let's look at Phase 1, the first review. The procedure is as follows. So the parties who want to merge will go online to the FCCPC portal. One of the merging parties can apply on behalf of both of them. On the portal, they will fill what is called Form 1, which is a notice of merger, and it will be accompanied by a non-confidential summary of key information, details of the merging parties, relevant financial documents, annual turnover of the parties, etc. If it's a public company, you have to notify SEC. Now, within 5 business days of FCCPC receiving an application, FCCPC should let you know if they are satisfied with what was submitted. According to the merger review guidelines, it takes them 3 business days to determine if your submission was satisfactory or not. If your submission was satisfactory, then within 2 business days, FCCPC will publish a notice of the merger on their website or in a gazette for the public. This will contain the non-confidential summary of key information that was in Form 1. This notice is known as Form 1A. You'll also get a draft of this Form 1A in your email that you can serve to third parties. Now, this publication of Form 1A will also invite interested parties like competitors, consumers, suppliers, etc. to drop their thoughts on the merger. The parties to the merger have the responsibility of serving copies of this Form 1A to the interested persons to make sure they get it. In the case of a small merger, they have to drop their written submissions within 3 days after the publication was put up by FCCPC. For large mergers, they have within 7 days to submit their comments. They can also be sent by email. Now, before FCCPC kickstarts the investigation, upload proof of service of Form 1A that you served these interested third parties. It may come in the form of an acknowledgement letter, an affidavit of service, or a receipt of a courier service like DHL. Upload it as part of your required documents for Form 1. It was incomplete before, but this proof of service will complete it. It goes without saying that if the Form 1 was incomplete, excluding the proof of service of Form 1A that would be uploaded later, then FCCPC won't publish the Form 1A on their website or in the public gazette until the merging parties fix it. Just double check, make sure that you uploaded everything right, and keep checking it until they are satisfied. Now, after the notification is complete, FCCPC will go ahead to process the merger to see whether or not it would substantially lessen or prevent competition. For small mergers, this happens within 20 business days after successful notification, and that may be extended by a single period not exceeding 40 business days. This is what the Act provides for. For large mergers, this happens within 60 business days after successful notification, and that may be extended by a single period not exceeding 120 business days. This is what the Act also provides for. Now, the regulations may look like they provide for different timelines, and while that's true, there's a reason for that. The extensions provided by the Act are the maximum, and so the regulations that came after the Act are meant to make the process more efficient. This is why it gives the reduced time for extensions. What I'm saying is that the regulations are not in conflict with the Act, but rather, they are aligned with the time frame given by the Act. So for small mergers, the first review should happen within 20 business days from the successful notice. If there are no issues, it gets approved or approved with conditions. If FCCPC raises concerns, but concerns that aren't so serious to trigger a second review, then that 20 business day period will be extended by 15 business days. In that time, the merging parties can propose acceptable remedies to fix those issues. If the remedies take care of the issues, then no problems. It either gets approved with conditions, or the merger gets prohibited. If FCCPC raises concerns that will trigger a second review, however, then the time extension is 40 business days, in line with the time frame given by the FCCP Act. For large mergers, the first review should happen within 60 days from the successful notice. But if there is no threat of anti-competition, Everything can be done within 45 business days. If there are no issues, it gets approved or approved with conditions. If FCCPC raises concerns, but ones that aren't so serious to trigger a second review, then that 60-day period will be extended by 30 days. In that time, the merging parties can propose acceptable remedies to fix those issues. If the remedies take care of the issues, then no problems. If FCCPC raises concerns that would trigger a second review, however, then the time extension is 60 business days, in line with the time frame given by the Act. Now, during this investigation phase, if they need more information from the merging parties, they would ask. They would run market testing and also review the comments from the third parties and contact them to ask what they think of the merger. This will be a quick summary opinion, not a detailed one. If FCCPC finds no issues, then the merger is good to go. If they start worrying that the merger will harm competition, then they will hold what is called a state of play meeting to let the merging parties know the problems hindering the process. They can also send an issues paper explaining exactly what worries them. Issues paper is basically just paper containing issues. Now the merging party would reply and suggest remedies, and another meeting can be had to further discuss these remedies. At the end of phase 1, FCCPC would make a decision. It would either approve the merger with or without conditions if the proposed remedies solved the issue, or it would move to phase 2, which is an in-depth investigation. In real life, companies almost never reach this phase 2 unless it's a very big deal. The FCCPC must make a report no matter the outcome, so whether it approves or decides to commence to phase 2, it must report it. Now let's look at phase 2, the in-depth investigation. But before we jump in, let's quickly revise the time frame again. For this second phase, small mergers will be extended by 40 days in addition to the original 20 days, and large mergers will be extended by 60 days in addition to the original 60 days. You got that? Alright, let's continue. In this second phase, they will go all out to investigate the merging company. They would ask for internal documents, they would run studies analyzing the economic impact of the merger, they would visit the offices of the parties, run surveys involving different questionnaires to market players, etc. Now this time the opinion of the third parties will be very detailed, unlike the summary opinions in phase 1. Now FCCPC would hold another state of play meeting, where all the findings it made will be stated. This is not a mere issues paper this time, but a full-blown statement of objection, which is way worse. The merging party would reply in writing addressing all the issues contained in the statement of objection and propose remedies to fix the issues. Third parties and the public will also be invited early in phase 2 to speak at the hearing. They will have talks and debates about the merging companies and the risk of competition. Then there will be another oral hearing, but this time it will just be for the merging parties and FCCPC. It won't involve the public. It will be like a mini trial, where the merging parties will be able to defend the merger. For them to achieve this, they can bring professionals like lawyers, economic experts to help their case. Now at the end, whether phase 1 or phase 2, FCCPC would issue a report called Form 3, which would say one of 3 things: that the merger has been approved unconditionally, which is good, or that the merger has been approved with conditions, which is okay. These conditions could be to sell some assets or keep prices of goods low for a period of time, etc. The report could also say that the merger is prohibited. In the case where the approval given is conditional in nature, or there is an outright prohibition, FCCPC has within 10 days of the decision to give the merging parties a report stating the reason for its decision. Side note, if a small merger that has already been merged happens to be anti-competitive, and FCCPC prohibits it, then that merger would have to be dissolved. When the merger is approved, FCCPC will issue a certificate of approval. Sometimes they just send you a letter of approval. That works too. Then the FCCPC will also publish the decision, which is Form 3. If it's a small merger, it will be published in a federal government gazette. If it's a large merger, then it will be published in at least 2 national newspapers. When the approval has been gotten, that's when the merging parties can finally implement the merger to make it binding. Now it's time for post-merger. Now, within 2 weeks of completing the merger, submit necessary documents to the FCCPC like a certified true copy of the court order sanctioning the scheme. This is when it involves a public company. You would also submit evidence of compliance with any conditions set forth by the FCCPC. And then you would submit reports on employee arrangements and financial adjustments. Stuff like that. As always, FCCPC will inspect the activities of your merger within 3 months after the approval. They will do this to check if you are complying with the regulatory requirements, and they will assess how your newly merged entity is performing in the market. And that is all for the main merger procedure. But to tie up some loose ends, let's talk about one more procedure, the simplified and expedited procedure. Now, if the merging parties will feel like the merger will not substantially lessen or prevent competition, and there won't be any evidence uncovered during investigation by FCCPC, then they can use one of two procedures. That is, either the simplified procedure or the expedited procedure. First of all, discussions with the FCCPC during pre-notification consultations are recommended. This is so that the merging parties will know if their merger qualified for this simplified process. Some things that FCCPC will consider are small mergers who voluntarily notified FCCPC, they will qualify. Also, companies who are not competing at all. So basically, companies in different businesses that are not overlapping horizontally or vertically, they will qualify as well. Also, if the companies are competing, but their combined market share is less than 15%, which is too small to be considered a monopoly anyway, they will qualify in that instance. Also, if the companies are involved in upstream and downstream of the same product market, and each of them has less than 25% in their respective markets, they can merge. So for example, in the oil and gas sector, if company A, who is involved in drilling and extracting crude oil, which is upstream, decides to merge with company B, who is involved in refining the crude into fuel and distributing the finished product to consumers, which is downstream, each of them need to have less than 25% in their various sectors. In other words, company A needs to have less than 25% in the upstream market, and company B needs to have less than 25% in the downstream market. If that is the case, they will qualify for the simplified procedure. Lastly, if one of the merging parties already jointly owns the other company and wants to get 100% sole ownership, then that can work. So the simplified procedure is basically this. One of the merging parties will just go online to the FCCPC portal and fill Form 2 instead of Form 1. When it's time for investigation, it will take 20 days for the small merger and 45 days for the large merger. Since it won't be stressful, you will get approval immediately. Always take note that if the FCCPC feels like the facts you are presenting are inaccurate and unwarranted, they'll just tell you to use the normal procedure. That means they'll tell you to fill Form 1 instead of the Form 2 you filled. Now, we'll be looking at expedited procedure. This one is what I like to call the fast-track procedure. It's used in situations where the merging parties are in different sectors or it's some type of foreign merger. Now, what happens when FCCPC approves this expedited procedure? Well, what it does is that it reduces the time frame of phase 1 down by 40%. So for small mergers, instead of 20 business days, we'd have 8 business days. And for large mergers, that's 18 to 24 business days. This is the math right here. So we've been talking about all the procedures for mergers. But did you know that just because a merger had been approved earlier doesn't mean it cannot be revoked later? FCCPC has the right to revoke a merger that was approved or conditionally approved based on the following. If the approval decision was based on incorrect information submitted by the merging parties, that is when they were submitting their Form 1, then it would be revoked. Also, if the approval was obtained by deceit, it would be revoked. If after 12 months of the approval, the merging parties don't implement the merger, it will be revoked. Finally, if one of the merging parties breaches the obligations attached to the decision to approve the merger, it will be revoked. Okay, what else am I leaving out? Oh yes, I just realized I hadn't talked about types of mergers. Some textbooks call them the economic forms of mergers. There are 3 main types of mergers: horizontal merger, vertical merger, and conglomerate merger. A horizontal merger involves 2 companies in the same industry, often competitors, combining to increase market share, reduce costs, or improve efficiency. A hypothetical example I can give of this is when a company like MTN, that's in the telecoms industry, decides to merge with another company like Airtel, which is also in the telecoms industry. When combined together, they have the possibility of being a telecom giant with larger network, customer base, and potentially lower operational costs. The next is vertical merger. A vertical merger involves companies at different stages of the supply chain in the same industry. So another hypothetical example I can use, this time we'll look at the cement industry, would be if Dangote Cement, that's into cement production, decides to merge with Julius Berger Nigeria, which is into construction, and buys cement. What this merger would do for both parties is that Dangote Cement gains a guaranteed customer, while Julius Berger secures a stable cement supply, optimizing costs and operations. Another example of this is the upstream and downstream I was talking about before. So in the oil and gas sector, a company involved in drilling and extracting crude oil, let's say for example Shell, would then merge with another company involved in refining the crude into fuel and distributing the finished product to consumers. So a company like Dangote Refineries. Speaking of Dangote, it's time to jump into conglomerate mergers. A conglomerate merger involves companies from unrelated industries combining to diversify operations, reduce risk, or expand into new markets. The Dangote Group is a prime example of a conglomerate because this group has diverse interests in things like cement, sugar, flour, logistics, real estate, telecommunications, oil and gas, etc. Basically, all these companies are operating across multiple, often unrelated industries, making Dangote Group a Nigerian conglomerate powerhouse. Wow, no wonder he's on the Forbes list. And that is all you need to know about mergers in Nigeria. All resources I've made reference to will be put in the end of the video if you're interested. Thank you very much for watching, guys. Like, subscribe, and share with your friends. And I will see you next time.